Good morning, everyone. Welcome to our live assembly this morning. This morning we are joined by Dr. Mark Eccleston-Turner from Keele's Law Department, who's going to be talking to us all about COVID-19 and what the law has got to do with it. Thank you so much for joining us today.
Thank you. Thanks for having me. Okay, so thank you very much for everyone for joining. It's great to be able to do this, and as Laura said in the introduction there, I'm Mark Eccleston-Turner. I'm a lecturer in the School of Law, and I actually specialise in infectious diseases and the law. So as I'm sure you can imagine, it's been an incredibly busy year for me with the pandemic. But we all know that COVID is this great health crisis. We know that it is a health concern. We know that it puts pressures on the NHS. We know it's affected frontline healthcare workers. We know that it's affected loved ones and people we care about. We know probably all of us here know someone who's caught it, and unfortunately some of us may know people who've become incredibly unwell with the virus. But what I want to talk to you about today is something which I find really interesting, which is the fact that COVID isn't just a health issue. It's actually a legal issue as well. And what I'm going to do over the next 20 minutes or so is talk to you about how COVID has affected the law, and not just affected healthcare law, which I'm going to talk about at the start. I'm going to talk about how COVID has affected lots of different areas of law, and probably areas of law that you've never even considered COVID might impact upon. So the first and most obvious impact that COVID has had on the law is its impact upon healthcare law, upon the law of the NHS, or the law that regulates how medicine is delivered in this country, but also internationally. And COVID has thrown up a number of really interesting challenges in that regard. First of all are the challenges which are presented by COVID when it comes to access to medical treatment. So as we know right now, we have a vaccine, and that is an extraordinary achievement. It's something which a year ago we could never have anticipated, that we would already have safe and effective vaccines against this strain of COVID. But that vaccine raises a number of really important legal issues, like who can get it, like what priority individuals can get the vaccine in, and how that vaccine is accessed equitably around the world. So first of all is the question of how do governments get hold of vaccines in order to immunize their populations? And we know right now that globally there is a huge inequality in equitable access to medicines. Over 95% of the vaccines which have been delivered, have been given during this pandemic already, have been given in high-income countries, have been given in the wealthiest countries in the world, like ours. And from our point of view, that makes us very fortunate. That puts us in a very, very privileged position, in that we are now protected against the virus, or some of us are protected, our loved ones are protected, and herd immunity can begin to take hold in the UK. The problem of that is that the vaccine is a finite resource. There are only so many doses available at any one time. We can only make so many doses at any one time. And wealthy countries like the UK and the European Union and America and so on have purchased almost all of those vaccines for themselves. And as a result, low and middle income countries, developing countries, poorer countries are not able to access the vaccine. And because they can't access the vaccine, their healthcare workers aren't immunized, their high-risk groups aren't immunized, their key workers are not being immunized in low and middle-income countries. So at the moment, in the UK, we have immunized over a third of our population. And that's an incredible achievement. But the counteract to that is, because we have purchased so many vaccines in order to vaccinate so many of our population, there aren't enough vaccines to go around at the global level. So across Southeast Asia, across Africa, across Latin and South America, people aren't vaccinated. And when they're not vaccinated, they're more liable to be infected by the virus, but also the virus can circulate more broadly and strain mutations can happen. So there is this global question of equitable access to vaccines, and how do we ensure that the poorest countries in the world and their populations can access this vaccine and can access it quickly as a route out of the pandemic for the entire world. But even within the UK, there are questions about who gets the vaccine. There are questions about prioritization, about whether healthcare workers should receive the vaccine before people who are 60 or 50, or when teachers are going to receive the vaccine, or when academics who work with students like myself will receive the vaccine, or people who work in shops. All of these give rise to legal issues about access to vaccine and access to medical treatment and prioritization of medical treatment. And this comes down to questions of what we call healthcare rationing. When you have a finite resource, when you have a resource which cannot easily be spread around the world, or there's not enough of that resource to go around, what is the right and proper and fair way to share that resource out amongst a group? And that's a really challenging question. And what we see is that there is guidance from organizations like the World Health Organization as to what they think the most scientifically beneficial way to do it from a public health perspective. But the scientific perspective on sharing the virus might not actually be the fairest way to share the vaccine, might not be the most equitable way to share the vaccine, because we know that the burden of the virus, the impact of the virus, is being felt more acutely in certain groups, certain socioeconomic groups, like people who are from lower socioeconomic backgrounds, people who come from working class backgrounds, are more susceptible to the virus because they tend to work in jobs where they get exposed to the virus. And also there is a higher proportion of people from ethnic minorities who get exposed to the virus because they tend to work in those job markets as well. So there's an issue here with just distributing the vaccine on the basis of the scientific information might not actually be the most fair or equitable way to distribute the vaccine. In the early stages of the pandemic, when there was no vaccine and there were limited treatment options available, one of the major concerns was that the healthcare system would be overrun, that we would run out of intensive care beds, we'd run out of ventilators. And in response, we created these Nightingale hospitals, where we took over buildings like the Excel Centre in London and these major centres in order to triage patients. And that gives rise to some really interesting legal questions as well about who, if there is a limited number of ventilators and more people who are sick than ventilators available, who goes onto the ventilator and how do you make that decision and who makes that decision? All of these are really important legal questions which the pandemic has thrown up for us. But as I said, pandemic doesn't just bring up these legal questions in healthcare law. It actually impacts lots of other areas of law. The first thing that the pandemic has impacted is our constitution. The constitution is the legal arrangements of Parliament and how decisions are made within by government and by Parliament. And the pandemic has impacted that in two really important and interesting ways. The first thing is the fact that there has been a separate response to the pandemic in Scotland and Wales as compared to England. And what that impacts is what's called devolution. Devolution is the fact that Scotland and Wales have their own parliaments, and those parliaments have decision-making ability around certain issues, like healthcare, for example. So this is why there has been an inconsistent application or an inconsistent response to the pandemic in Scotland and Wales. And that's why there has been some potential confusion around the rules, because actually Wales and Scotland make their own rules around the pandemic and their own rules within lockdown, which is why you get situations where my mother, who lives in Swansea, was not in lockdown whilst I was here living in Stafford. And you get these inconsistent applications of the rules across the borders. But one of the really interesting parts of that is the perceived better response from Scotland and Wales has actually instigated and kick-started further talks of increased devolution, so further powers transferring from Westminster Parliament to Scotland or to Wales, or even pushed independence, the independence movement in Scotland and Wales, where the idea that Scotland and Wales, certain people with certain aspects of society within Scotland and Wales want to be independent countries and break away from the United Kingdom. COVID has also impacted the Constitution in how decisions have been made about lockdowns and how certain public health decisions have been made. And this has been quite a controversial area. So Parliament has used emergency measures. Emergency law, government has made used emergency lawmaking powers to pass public health measures, so measures related to lockdown, so putting certain places into lockdown, easing lockdown, opening lockdown. Those decisions haven't been made by Parliament, by both the House of Commons and the House of Lords sitting as a full chamber. Instead, those decisions have been made under emergency measures by the government itself, without going through the traditional scrutiny of Parliament. Now that raises certain questions, given how much lockdown and the easing of lockdown, or putting places into lockdown, can affect things like public health, but also affect things like human rights, liberty, and the economy. So there are questions regarding the relationship between government's decision-making ability in an emergency and parliamentary oversight and Parliament's scrutiny of those decisions. Parliament is an important check on the power of government. But one of the problems is that Parliament hasn't been able to sit fully, because of the risk of the pandemic, in order to scrutinise government decisions. Parliament is having to sit virtually or sit within limited and reduced numbers, and that limits the ability for the Parliament to act as an accountability check on the work of government. So that gives rise to really important questions about the relationship between Parliament and government, and the oversight of decisions which are taken by government by Parliament. COVID has also impacted criminal justice in a very, very important number of ways. So first of all, through those emergency powers, through the response to the pandemic, the coronavirus regulations and the Coronavirus Act, which have been passed by government and by Parliament, certain new criminal offences have been created. So we're creating new criminal offences by statutory instrument, by these government regulations. So things like, if you were to meet someone outdoors who is not part of your household bubble or not part of your family, you could be liable to a fine from the police. That is creating a new criminal offence, and that links into the problems we have with lack of government oversight, lack of parliamentary oversight of government decisions. So first of all, we've got created new criminal offences, and new criminal offences which have been created and designed in order to better protect public health. And there's a really interesting relationship there with the fact that there are questions about if we should use the police in order to enforce public health rules, or whether actually making the police involved in enforcing public health rules actually could cause more problems, because it erodes public trust in the public health rules. What we tend to want is a separation between policing and health. But what we've done through coronavirus is link those two together, where we're actually using the police to enforce public health rules and enforce public behaviour for the benefit of public health. That's quite a new thing which we've seen in this pandemic, and it does raise some really important questions about the role of the police and the role of public health, and where and how they meet. The criminal justice system has also been impacted by in that regard by the fact that the rules which have been created and enforced by the police are at some points quite confusing and quite difficult to understand. And as a result, there have been noted inconsistencies between police forces. So the police force in Staffordshire, for example, understand and apply those rules differently to Thames Valley Police or South Wales Police, for example. So you get a situation where these rules are being inconsistently enforced and understood and applied by different police jurisdictions. And therefore, you get inconsistent application of the law. And inconsistent application of the law is something which we try to avoid in law. It's not a good thing. It's bad for the rule of law, and it's bad for justice. Justice should be given fairly and given equally, no matter where you are in the country. But what we're seeing with the coronavirus rules and the police enforcement of those rules is that there's an inconsistency there, and that's a real problem for justice. One of the other major problems that COVID has caused to criminal justice is that the criminal justice system itself, the court system and the prison system, has ground to a halt because of COVID. So in order to minimize and prevent the spread of coronavirus and mitigate against its impact, courts have not been sitting. But crimes are still occurring, people are still getting arrested, and cases are still getting slated. We're at a situation now where people who are getting arrested now are having their court appearance scheduled for 2 years from now because there is such a considerable backlog of cases to get through. Now, depending on the level, on the severity of the crime which you have been charged with, those 2 years you may end up on remand in prison. And remember, you may spend 2 years in prison for a crime which you were eventually found not guilty of if you're kept on remand. Or if it's something that's not as severe, you might not be kept on remand, but you may be you may have some degree of liberty, but you may have to report to a police station regularly and so on. But the main thing is that justice delayed is justice denied. One thing we really need and really want is a prompt, swift, fair justice system. And we talk a lot at the moment about the importance of a well-funded, well-regulated, well-working public health system in response to the pandemic. What about our well-funded, well-resourced, efficient, well-working criminal justice system? It's equally as important to us as a society to have a well-functioning criminal justice system. But at the moment, the wheels of justice are coming off because the courts are not sitting at the moment. There have been some attempts to set up Nightingale courts to deal with this backlog. But going into the pandemic, the courts were underfunded and there was this huge backlog of cases. And that's only been made worse now by COVID. So we have a real issue where justice is being delayed. And that is not good for A, the victims of crimes, but B, the people who are put on trial for those crimes. You have this and you know, let's remember, not all of them will be found guilty. You have all of this hanging over your head, waiting for your trial, which may not come for another 18 months, 2 years. That's a real problem for justice. COVID has also impacted contract law in a really important, quite interesting number of ways. So first of all is this idea of what we call force majeure. So force majeure is a clause which will be in pretty much every contract you have ever signed. The contract you signed on your phone, the contract you signed, you know, when you book a holiday, will have what's called a force majeure clause. Now, force majeure are acts beyond your control, things which are outside of your control. So let's say, for example, you were a band and you booked to perform a gig at a venue. You've paid for that venue, but then the venue closes because of COVID and because of lockdown. Who's liable to pay for that? Who, you know, is it the venue which has locked its doors, or the band? Do they have to continue paying? Because neither the band nor the venue has attempted to breach its contractual obligations, but things have happened within the world which prevent both parties to the contract from being able to meet their contractual obligations. And then you have questions of who pays for that. Contract law is also, and COVID is in the news right now. I'm not sure if you saw, but yesterday the European Union blocked exports of the COVID-19 vaccine from going to Italy. So vaccines which were made within the European Union had been purchased by the Australian government. So there was a contract between the Australian government and AstraZeneca, for example. And before AstraZeneca could load those vaccines onto a flight to ship them off to Australia for AstraZeneca to meet its contractual obligations, the European Union stepped in and prevented them from exporting those vaccines and said, those vaccines aren't leaving, we need them because our demands haven't been fulfilled yet. What happens then? AstraZeneca has failed to meet its contractual obligation to the Australian government, but it tried to meet its contractual obligations. It was prevented from meeting its contractual obligations because of the acts of other people, because of the acts of the European Commission. Who is liable in these circumstances? These are really important, really interesting legal questions that COVID has created and thrown up. And the final thing I just want to talk about at the moment is the effect that COVID has had on human rights. The effect that COVID has had on, for example, the right to an education, which is impacting you all right now. You know, your ability to access educational resources and access school. That is something which is enshrined within the Universal Declaration of Human Rights. But because of the response to the pandemic, the lockdown has meant that you have not been able to access schooling. So we've had to create these team meetings and these Zoom meetings to try and enable all of you to receive your education as you're legally entitled to do so. And because we are fairly fortunate in this country, most people have a laptop, most people have a broadband internet connection. We have been able to adjust, we've been able to move and put things online and enable you all to get your education as much as possible. In large parts of the world, that's simply not possible. In large parts of the world, there isn't a well-functioning broadband system. You don't have a laptop in your home. You might not even have regular electricity. So how do you access education then when your school has been closed in response to the lockdown? And there is this balancing act that is pervasive across all of human rights, but also across all of public health, which is the balance between what you are trying to achieve with lockdown, for example, which is to prevent excess mortality, prevent excess morbidity, and protect the NHS, with the fact that you are infringing upon individuals' rights in order to do so. You are not allowing them to go to certain places. You're not allowing them to access certain resources which they ordinarily require and which they do have a human rights obligation to. So inherent within all human rights is this balancing act of trying to balance one right against each other, trying to balance the public health benefit with the infringement which is occurring through things like lockdown. And I think the fact that lockdowns have happened in different ways, first of all, within the United Kingdom, but also across the world, there is no consistent application to lockdown, and the response to the pandemic raises some really important, interesting legal questions about human rights. But I'm going to leave it there in terms of my talk. I know we've only got a few minutes left, and I want you to have the opportunity to ask any questions or raise any issues which you have. But thank you so much for your time, and we'll go for some questions now.
Brilliant. Thank you very much for that. That was a really, really interesting talk. Yeah, we've got some questions that have come in. The first one is about, you said about the vaccine, we've only got a finite amount that's available. How do we make that more fair globally?
That's a really, really important question, and it's a really difficult question, and there are mechanisms in place like COVAX, which you might want to go away and look up. So COVAX is the WHO mechanism which is trying to purchase vaccines to distribute to low and middle income countries to try and make equitable access more fair and more equitable. The problem with that is it's severely underfunded. It has billions of dollars of shortfall in its budget. Because of that, it can't purchase enough vaccines in order to roll those out to low and middle income countries. But part of this also comes down to the fact that because of intellectual property rights, because of patents, there are only a limited number of manufacturers in the world who are allowed to make the vaccine, because you can't make it unless you own the intellectual property. So we have this huge issue where there are manufacturers in the world who are able to make more of the vaccine, particularly the AstraZeneca vaccine, and they're not allowed to do it because AstraZeneca won't let them, because AstraZeneca is the patent holder. So I think one thing that we need to do is really take a fundamental look at the pharmaceutical industry and how we incentivize them to create new vaccines, which is what we want them to do, but also how we can ensure that equitable access can happen in low and middle income countries. And it's a real problem.
Yeah, definitely something for us to think about, isn't it? Another question that's come in is about when you were mentioning about the new criminal offences being sort of made into law as such. Will they always will we always have those now, or will they be they there for a finite amount of time, or do you think we will always have these criminal offences?
No, I don't think we will always have the criminal offences. The criminal offences which have been created are part of the coronavirus regulations, and those will exist for a finite amount of time up until the point the pandemic is over. But then I think there will be really interesting questions about how we reform public health law more generally. And part of that may involve giving further policing powers in regards to public health to police forces. And I think we have to think very, very carefully about the role of police in enforcing public health rules, because it does have real issues of trust and real issues of the relationship between the police and public health. And I think that's something we need to think very, very carefully about.
That's brilliant, thank you. And the final question that came in was about career advice, really. If somebody wanted to go into the type of work that you're doing, they're really interested in sort of the law around diseases, how do they go about getting into that area?
So I think one of the first things you could do is look to study a law degree at undergraduate level, and potentially, if you can, where you study, take modules that are outside of the law school and study some modules in a medical school or a school of global health around immunology or around public health or infectious diseases. That would be a really good thing. And then what you do is you become, if you want to do what I do, is you end up becoming more and more specialist as you go on. So I did my PhD in global health law. I studied a PhD in global health law. And you become more specialist as you go through. But I think a really good starting basis would be to study global health, would be to study a law degree at undergraduate level. And if anyone who's listening does want to go into the sort of career I do, or wants to have any discussion about careers, I am the admissions director for the School of Law at Keele. So please look me up online, just Google my name, you'll find my email address, and drop me an email and I can give some more specific career advice. But a good undergraduate degree in law is a good start, and then you can do things like postgraduate study in infectious diseases and postgraduate study in medical law and global health law, which is what I did, until you end up in the situation where your research becomes your life, which is up until 18 months ago, I was reading and writing and thinking about and teaching about a fictional pandemic, which one day might happen. And now we're living in the middle of my research. So it's quite an unusual thing. But yeah, a law degree, and then try and specialize more and more in infectious diseases. But if you want to email me, please do feel free to.
Brilliant. Thank you very much. Thank you so much for your talk today, Dr. Eccleston-Turner. That was really, really interesting. Lots of things to think about there. If anyone watching does have any other questions, you can get in touch with us at higherhorizons.co.uk/ask, or check out our website. Thank you very much for joining us today, and we will see you again soon.
Thank you so much. Bye.